and kick things off. Good morning or afternoon, depending upon where you're tuning in. And welcome everyone to the American Family Insurance DreamBank, where we believe in the transformative power of dreams. My name is Andy, and on behalf of the entire DreamBank team, thank you so much for taking time out of your day to join us here. As we get started, we always like to learn where our community of dreamers are joining us from, and I encourage you to share. So in the chat section, if you're comfortable, I am from sunny downtown Madison, Wisconsin today. Um, Not quite fall yet, which I'm excited about. So for those of you who attended our virtual or in-person events in the past, welcome back. And for anyone who is joining us for the first time, I'd love to take a few moments and just introduce you to DreamBank. So at DreamBank, there is something for every dreamer. Here at American Family Insurance, life is better when you're under our roof, because when you feel totally supported and protected, any dream is possible. And that's why we created DreamBank. It's an inspirational and community destination and virtual experience that's designed to help people pursue, achieve, and protect their dreams. From weekly events to immersive signature programs, special events, and on-demand content, our free programming and resources are designed to bring you inspiration, motivation, and support no matter your interest. So go ahead and check out our upcoming virtual and in-person events at amfam.com/DreamBank and reserve your spot today. A couple housekeeping items before we go ahead and kick things off. If you have any questions for myself or for Amy, go ahead and use the chat section. We'll try and get to as many of those questions as possible. In addition to that, there's a post-event survey that will be coming to the email address in which you use to register for this event today. It just takes a few moments to fill out and really helps kind of dictate and determine the types of content that we put out for you. So we'd really appreciate if you all could take just a few moments and fill that out. But today we have Amy Devine chatting a little bit about the impact of estate planning. So without further ado, I'm going to go ahead and kick it over to Amy to do a little introduction and talk about just that. So Amy, go ahead and take it away.
All right. Thank you very much. Good to be here. Thank you, everyone, for taking time out of your day-to-day to attend this seminar about estate planning. I know not always the most fun topic, but really important, especially as we get older, to think about kind of what happens if we can't make decisions for ourselves. And then after we pass away, after our death, what happens to everything we own and the people that we love. So here we go. So this is me. I've been an attorney for about 19 years now. I'm one of the partners at Haskins Main Devine. We're located in Monona, east side of Madison, and we are an elder law firm. I'll talk a little bit about that. I've had a few different hats during my tenure as an attorney, but this is kind of where I've landed, and what I think enjoy doing the most is working with folks going through kind of estate planning and what does that mean. So estate planning, elder law. As I mentioned, we are an elder law firm. We work with people of all ages, right? So as long as you're over 18, you can engage in estate planning. But we also do a lot of other things here. So we do, wills, trusts, right? Powers of attorney, kind of basic estate planning. We also work on with guardianship. So anyone over the age of 18 who might need a decision maker appointed by the court. We work on long-term care issues. We help people with Medicaid. That is the long-term care program that will help pay for nursing home stay, assisted living facilities, care in the home. And then also do a lot of special needs trusts and kind of special needs planning. We have 3 attorneys, and we all do this kind of work. So this presentation today, we have about an hour. This is a lot of actually what I talk about when I meet with clients for the first time is, what is estate planning? And really some of these are kind of the biggest questions that I get. And the idea is that hopefully we can answer these questions. And then with that, we can feel a little bit better about, our paths moving forward, that we've made some decisions, we have things in writing, and we know that we're taking care of our loved ones. So what happens if I'm in an accident and I can't make my own decisions? What is an estate plan, right? Talked about, I use that word a lot. What is it? Can I avoid taxes? That's a really big question as well. Do I even need a will? Do I really need a lawyer to do this for me? All really good questions. And then finally, probate. What is probate? How do I avoid it? What does it mean to go through probate? And I'm licensed in both Wisconsin and New York. That's where I went to law school. But I really I only really practice in Wisconsin. So everything I'm telling you today is primarily it's based on Wisconsin law. As you know, every state does things just a little bit differently. So if you are joining us from another state, these are really good concepts and ideas to think about. But I would suggest reaching out to an attorney in your own state to make sure that you're following that state's laws. So I kind of just paint a little bit of a scenario, right? Imagine this, right? I'm at work, I get a call, my husband's been in an accident. So I go to the hospital, figure out what's going on. He's got surgery, recovering. Maybe he needs to go to a facility for a period of time to relearn certain skills. During that time, right, I'm operating in kind of in an emergency state, right? Making decisions, taking care of things. But as things proceed, I realize that I actually need authority to tap into his retirement account to pay for some of those medical bills. Maybe now I want to sell our house because he has limited mobility, and now I need to downsize. I need a house that's just one floor. I will quickly find out that if I am not his power of attorney and his name is on some of those assets, right, the house or the retirement account, I won't be able to access them without being his power of attorney. So it's really important that really anyone over 18 is kind of thinking about these things and making sure they have them in place. So power of attorney. In Wisconsin, we have really kind of two documents. We have a healthcare power of attorney, a financial power of attorney, right? Handle really kind of two different things, medical decisions and then anything related to finances. Here in Wisconsin, we actually don't have anybody that is technically your automatic decision maker. We are not what some other states might call a next of kin state. So that scenario where I played where I'm in the hospital, I might be able to make an emergency decision, but long-term decisions about my husband being in a facility, that's something I'm not going to make unless I'm a power of attorney or a guardian. Again, other states are a little bit different, but in Wisconsin, this is how we operate currently. Really, anyone over 18 should have one. We've actually had kind of an ongoing project here, started during COVID, where college kids, they're 18, going off to school, parents worried, what if my kid gets sick? No one's going to talk to me, right? They're an adult now, so we help them prepare healthcare and financial POAs just in the event that something happened while they were away at school. Wisconsin is a marital property state. We are actually one of 11 states in the country that has marital property. So even though a lot of things we have, if we are married, right, we hold them jointly, we can both access them. As I mentioned, my husband's IRA, retirement account, even selling our house jointly might be difficult if I'm not a power of attorney. We're also trying to avoid guardianship. And guardianship, I could probably talk another hour about. So I'll just kind of briefly describe. It is the court process where somebody, goes to a judge. That person is actually declared incompetent if they can't make their own decisions, whether regarding their person, like care and custody of their person, or for their estate, for their finances, for their money. It's a process, I think, especially that I'd want to avoid for my own spouse, my own partner. And that's why I want to do a power of attorney to try and avoid seeking guardianship and having to going to court, which can be expensive and time consuming. I also just add that, we always think that we have more time to do this type of planning. I am seeing, I think, more people where they've waited a period of time, and now there are some questions about whether or not they have capacity to sign these legal documents. And kind of once we've crossed that threshold, it's really difficult to go back in time or to have them sign a will or a trust or a power of attorney if they're at a point where they're not really understanding what they're signing. And then on the flip side of that is, we handle probate here, kind of any post-death administration, whether it's for a will or a trust. And, I meet with people where they were upset somebody didn't do a will, or the person who died did a will, but it was done 30 years ago and really doesn't reflect their current wishes as everybody understood them. But unfortunately, for the most part, now that person is gone, we can't go back and do a new will. There might be some things we can fix, but for the most part, at that point, we're left with whatever that person's will is and what's in writing. So, what is an estate plan? An estate plan can really comprise of all of these documents. And so a will, I think, is something we're all pretty familiar with, right? We name our executor, the person who's going to be in charge of handling things when we die. In Wisconsin, we call that a personal representative. We say who's going to get our tangible personal property, right? Our tchotchkes, our car, our clothing, furniture. And then we also say who gets kind of everything else, excuse me. So they get what we call the residue, whether it's any accounts, house, those kinds of things. A trust, and I'll go into that into a little bit more depth in a little bit, but that's another type of estate planning document. A trust is something that really, you still have a will if you have a trust, but with a trust, you're really using it as your driver for your estate planning document. You place things in a trust. Your trustee then is the person who kind of manages things for you. They can manage them during your lifetime. They can manage them during your death. And then ultimately at your death, your trustee is going to be in charge of distributing your property according to the terms of your trust. There are a few different kinds of trusts. One common one is a revocable trust or a living trust, and that is one that somebody can really change at any time, and they can use it really as their primary estate planning vehicle. There's also what's called an irrevocable trust or a Medicaid asset protection trust, and those are used when we're thinking about potentially long-term care and having assets really protected in that type of trust. I mentioned the powers of attorney, right? Both your financial power of attorney and your healthcare power of attorney. You don't have to name the same people for both of them, but those are people that will be managing things for you if you're not able to do that on your own. There's an authorization for final disposition. It's kind of a funky term. It is really what happens when you die. You have your body, right? Who's in charge of that? Under statute, it's your spouse. If not your spouse, it would be your children. After that, we go to your siblings, parents, right? Kind of down the family line. These are forms I'd like to do for people where maybe they don't have a spouse or kids and they want a friend to be able to help them and do their funeral, cremation, whatever they're doing. So it's just a good way to have those kinds of wishes in writing as well. A living will is a little bit different from a healthcare power of attorney. Your healthcare power of attorney is very broad. It's going to basically say, if I'm incapacitated, I want my brother to make my healthcare decisions for me. There are a few specifics I'll put into it about placement in a facility or a feeding tube, but overall, those are conversations I'm going to have with my brother about what I want. The living will is very specific to if you have a terminal condition, or if you're in a persistent vegetative state, yes or no, you want a feeding tube, yes or no, you want certain life-sustaining treatment. It's not a bad idea to have both, but generally speaking, that healthcare power of attorney is going to be much broader because you're going to designate one person to make decisions for you in all different kinds of scenarios, many of which we really don't know what we're going to face, right? And we can't really imagine what we might be facing if someone else is making decisions for us. And then finally, there's a marital property agreement. Again, in Wisconsin, being a marital property state, in some cases, you might want to have everything titled as marital property, right? Both of ours. Some cases, you might want to exempt certain things out. Another version of this is kind of what we call the prenuptial agreement, right? The prenup. That typically you need two different attorneys. Each person's represented by one attorney, a little bit different than from one for an estate planning purpose. And in my world with an estate plan, what we're really just trying to do is make it easier so that if I pass, I'm leaving things directly to my spouse and categorizing them as marital property for that person. Another really key role, so we're looking at all those documents, but really a lot of it is figuring out who's going to do what in my estate plan. And that could really be anybody that's over the age of 18 that you trust, somebody that is responsible, organized. Hopefully you've got at least one person that you can name. I always encourage people to name at least two. So we have a primary agent, and then we have a backup just in case my primary agent isn't available. They don't have to live, in the same town or even the same state as you, especially now with technology, right? People can FaceTime, we can, get DocuSign, a lot of things. I really have people focus on, what does the person mean to you? Do you trust them? Can you have difficult conversations with them now about what you may or may not want, especially as related to healthcare, where they might be making some really difficult decisions? You don't have to name the same people for both, right? So before I was married, I went to my mom and said, "Hey, would you do this for me?" And her response was, "I'd be your healthcare power of attorney, but just so you know, like I would never pull the plug. I could never do that for you." And I thought, well, I'm not sure that's what I would want. And also, I don't think that I don't think she wants that responsibility as well, I think is what she was telling me. And so I picked my brother instead. And that was someone that I trusted, but also I could have honest conversations with him. And I think he would be able to make those decisions for me. So I just give that as one example about how you kind of think about who you're going to name. In some cases, we don't have people that we can trust, or we don't have people that we feel comfortable having those conversations with, or that we feel comfortable asking. I will say that there are some organizations out there that will serve as a healthcare power of attorney. And there are a few for financial power of attorney, but I would say they are few and far between. It is really hard to find a financial power of attorney if you don't have somebody that you can name and you can trust. And usually when I'm talking to clients, I encourage them to really cast a wide net and have those open and honest conversations with people. Sometimes you'll be surprised at what people are willing to do for you. So uh, just kind of a plug for having those conversations sooner rather than later. I would not want somebody to name an agent without talking to them first. We want to make sure they're signing on to know what they're signing on to. So during your lifetime, a power of attorney can manage things for you. If you can't, at your death, that pretty much ends. And then that's when we have a personal representative or a trustee who's coming in and taking over that decision making for us. All right, so do I need a will? Do I need a trust? All really great questions. So the way that I approach this is there isn't any one person who either needs a will or needs a trust. I want to understand what your goals are in your estate plan, kind of what you've got, right? What are your assets? And then also how do you want to distribute them? So, for example, if you were married, it's a long marriage, only marriage, and you have one child, and you're leaving everything to that one child, we could have a will, right, where we name, your child as the primary beneficiary. We would go through the other steps to try and avoid probate, and I'll talk about that. But that would be a fairly straightforward plan, and a will might work fairly well in that scenario. On the flip side, potentially, you have a couple of children, but you also want to do some charitable giving. You want to leave things to your nieces and nephews. Maybe you want to leave, you have a lake house, but you also have a house in Madison. You wanted to leave your lake house just to one child. In those scenarios, it's actually a little bit easier to use a trust. With a trust, you put your assets into it, and then that trust is going to say, okay, if my trust has an interest in this lake house, I want it to go to my daughter. It kind of becomes just an easier way to distribute property to other people. The idea being that everything kind of gets dumped into the trust and then distributed according to the terms of the trust. So let's say I wanted to give $50,000 to my church. I could have that in a will, but let's say I've gone through and I've named my only child as my beneficiary on all of my accounts, right? My IRA, for example, my life insurance. All of that money is going to go to that one person I've named as beneficiary. There may not be necessarily a pot of money to pay out that church. So again, if we're using a trust, we put everything into the trust, and then that trustee can hopefully write checks out to people or distributes assets to people that you've got named in your trust. The other reason for using a trust is if you have property in a different state. We always want to avoid property in another state that you're not living in, if at all possible, just because it's just more paperwork. It's another process to have to go to. So a trust can be good for that. It's also good for other types of planning where you have your own trust. Within your trust, you might have other trusts. So for example, if you have a child potentially with a disability, you want to create a supplemental or a special needs trust for them, you can have that as part of your own trust, your own planning. And then finally, if you've got minor kids, so for the most part, most of us, we don't want our kids just to inherit everything outright at 18 if they can. My kids are 4 and 7. I have no idea what their spending habits are, are going to be. But realistically, I probably would want them to get their money once they're a little bit over 18. So what do? I have my own trust. And then within my trust, it says, if both my husband and I are deceased and our kids are under the age of 25, right, they're going to have money held in that trust for them for their benefit. Their aunt is going to be the trustee. She'll be taking care of them and she'll be having access to the trust to help do that, right? Pay for college, other expenses. And then finally at age 25 or 30 or whatever age you pick, then they'd finally get kind of the full distribution, whatever is left. I will just add too, the other benefit of a trust is hopefully maintaining privacy. So if you have a probate, right, that is part of the kind of public record. Some of you may have been on CCAP, right? So if you go in there, you can check to see your neighbor's probate if you want to. You won't get all the details, but there's some information there you can find. So again, if that is a concern of yours, just one other reason to have a trust. So other steps, part of this, creating this estate plan, we want to be very thoughtful about how we have things titled and have we named any beneficiaries. At banks, those are usually called POD, right? Payable on death. For houses, we could do a TOD, a transfer on death deed. And then a lot of other places, life insurance, your retirement account, those will have what we call, really beneficiary designations. They all really kind of mean the same thing for our purposes. It's who's ever going to get the account at our death. So you might have a will that you've recently updated because you decided that, one kid needs more money than the other. So you're going to change the percentages. So now it's 80% to kid A and then 20% to kid B. But you left your life insurance policy a 50-50 split. Guess what? What you have in your will really isn't going to matter for that life insurance company because you've named those two people as beneficiaries. And generally, that's what's going to control. So you meet with me or another attorney, or you do a will online. You always want to make sure that, yes, you've got something in your will, but have you gone through all of your different accounts and look to see how they're titled and do they have beneficiaries? One other part that I talk to my clients about is any kind of funeral, burial, cremation plans. It's not something that's, super fun to spend money on during your lifetime. I personally haven't done this yet, but something I've thought about is at least having some kind of plan, and that way it's just not left to other people to have to plan or pay for. And depending upon what you want, right, it can be more expensive than other plans too. Okay, so I've used a lot of lingo, right? But we want to make sure that we understand the difference. So I talked about POD and TOD, right? Payable on death or transfer on death. Then there's also POA, right? Power of attorney. And working with my clients, it's not an uncommon experience where someone comes in and says, oh yes, I just added on this person as a joint owner of my account. It's just easier. That way they have access to it. And that's okay, but hopefully that's what you actually intended. As a joint owner, that person really, they'd have the right to take money out of that account for themselves as well. So we want to just really be thoughtful about when we are either, putting somebody else on an account, or if we're naming them as an agent, that we're actually filling out the right paperwork and doing what we intended to do. If, I pass away and I have now put my daughter on as a joint owner of my account and I keep a lot of money in that account, technically when I die, that money is actually hers. I might have intended that she was supposed to share it with her sister, but I made her a joint owner. And so the bank's going to say, well, she's a joint owner. Now it would be hers. There has been a little bit of kind of recent activity on this, just in terms of cases and people taking this issue to court. Again, I would say it's still something that you want to be really careful about if you're making somebody a joint owner, rather than instead putting them on as your power of attorney, making them your agent, their fiduciary. They can still help you pay all of your bills. It's just they're doing it wearing the hat of being an agent and not of being a joint owner. Okay, so what is probate? Again, every state is a little bit different about their processes. In Wisconsin, it is a court process. Now, you can go through probate with a will, you can go to probate without a will. It's really just how are we transferring assets from person A, the person who died, um, over to person B. So when I meet with a client, we will go through and try to get a good picture of all of the assets that the person had. We look to see, were they jointly held by anybody else? Do they have beneficiaries on their accounts? Is anything payable on death, or is there a transfer on death deed for the house? Or is anything held by their trust? If it turns out that there are assets totaling over $50,000 where we don't have that beneficiary named, or a POD or TOD, then we need a probate for those assets. And again, we're either following the will or we're following the statute that says what happens when you die without a will. And we are using that probate process to get the assets over from person A to person B. So a probate is not an all or nothing approach. There might be certain things, let's say the retirement account and life insurance had beneficiaries, but we forgot about anything for the house and we forgot about anything for the bank account. So the house and the bank account, that's what will go through the probate process. That will be part of the probate. And then the other assets, they're going to transfer to whoever is named as a beneficiary. $50,000 really isn't a ton of money once you start looking and adding things up. And it's a pretty hard cutoff. So I've had probates where we were just over 50,000. That was a process we had to go through. So I will say most often it's the house and the bank account that we don't have beneficiaries. And then we have probate just for those. So in the probate process, right, there's a decent amount of paperwork that you fill out. You actually don't need to have an attorney do this for you. Having gone through this process now, I think it is pretty paperwork intensive, but you can do it. You file notice in the newspaper. There's a creditor period or a claims period of about 3 to 4 months where anybody can who is owed a debt by the person who died, they can file a claim in probate, get paid out of that. And so there are a lot of steps and deadlines you have to follow that are part of the probate process. Initially, we do an inventory, right? What's all in the probate? And then after that, we start pulling everything together, and eventually we do a full an accounting of kind of what came into the probate, what came out. And then eventually we write checks according to the terms of that person's will, or distribute assets, however that will was written. Or we follow the statute that says, here's what happens when you die without a will. I would say typically the process lasts about a year. Sometimes we can do it a little bit under, but oftentimes because we have that claims period of 3 to 4 months, and we often have to wait a little bit of time to actually get the probate on the ground. Usually I would say a year or even more is kind of a healthy time frame for a probate. Okay, can I avoid taxes? So currently, the way that we have kind of set up estate tax here in Wisconsin, we do not have an estate tax in Wisconsin. So there isn't really a tax to avoid, at least from a state perspective. At the federal level, the limit is quite high. So in 2025, it is $13.99 million per person. So it's almost $28 million for a married couple. Next year, that's scheduled to go up higher. So it's going to be $15 million per person or $30 million for a married couple. So what does that mean? That means that unless you have $13.99 million or $28 million, you really don't have to worry too much about any sort of tax on your estate. There is a certain level of planning you can do, usually involving a trust, to try and avoid estate taxes, which most people want to avoid because they're typically quite high. They're really approaching kind of the highest tax bracket. So we're talking high 30s, 40% of tax. So if it is an issue, you do want to take those steps to avoid it. But really, for pretty much everybody that I work with, and a lot of us, we're really not having to worry too much about reaching that threshold. And if you do, then there are certain kind of trust type planning that you can engage in to minimize or reduce some of that penalty. I will say that otherwise, if there's an account that no one has paid tax on yet, so my IRA, for example, I haven't paid taxes on that money yet. So if somebody else inherits it and they take money out, they cannot avoid that tax when they take the money out. But it's not an inheritance tax per se, right? It's just the tax that is owed if anybody is taking that money out. When you inherit property, you inherit individually. So even though I'm married, if I inherit my mom's house, for example, technically it is considered individual property. However, if my husband and I then we move into it, he's putting money into it, even if it just stays in my name, if we ever got divorced, there'd be an argument that now we have converted it to marital property because we have put both of our money into it to either improve it, maintain it, use it. So I do get questions also about outside of just taxes is, can I protect money for someone who, my kid, right, if they're inheriting money from a spouse? And usually I say it's individual property. However, oftentimes we commingle it. They would have to really get a prenuptial agreement or a really more kind of complex trust to make sure that that money is kind of staying there for them and doesn't get mixed up if that child ever got divorced. So the long answer is, there isn't really any tax to avoid, and places where tax is already owed, there isn't really a way to avoid that. There is a benefit to inheriting property. It's essentially the step up in basis. So for example, my mom, they built their house in, let's say, 1980. I inherit that house. I now get a step up in basis, meaning that those gains between 1980 and 2025 essentially are erased during that time. So if I go around and sell it, I'm not paying tax on all of that difference. So there is a benefit from a tax perspective to inheriting property. It's just part of kind of what's built into what our laws and tax code are. Okay, what happens if I die without a will or without a trust? So Wisconsin has what we call the laws of intestacy. So again, I have died without a will. It's going to say who's going to inherit my property. Now, again, if you have named beneficiaries on your accounts, then those accounts are going to pass to those specific people. I usually find people have done kind of a mix, right? So some things have beneficiaries, some things don't. Maybe you had a beneficiary named, that person has died, and there was no contingent beneficiary. So now we're looking at either what your will says, or we're looking to the statutes if you don't have a will. So first up is to your spouse, and typically all of it is going to be transferred to your spouse, unless this is, a subsequent marriage where you don't have shared children, then potentially the children from your first spouse's marriage are going to inherit a portion of that, of anything that's not marital property. It's very complex and really fact specific. So if that's your situation, I would definitely recommend having a will where you can have or a trust where you can have things really spelled out about how you want somebody to inherit. If you don't have a spouse, then you have your children. Or if your child is deceased, but they had children, then it goes on to their kids. We use a legal term called issue, which really is just a fancy way of saying lineal descendants. So it doesn't include stepchildren, but it does include adopted children. After children, we go to parents. And after parents, then it would be brothers and sisters. And again, if not a brother or sister, if my brother had died, but he has 2 children, then it would go to his 2 children. And if generally speaking, I would say, his children are going to share in his portion. So in my scenario, let's say I don't have a spouse, I don't have kids, My parents have died. I don't have a will. I have two brothers, one of whom has died. They both had kids. The brother who is still alive, he's just going to get that half. My brother who has died, his kids are going to share in his half. That's kind of how it's broken down in the statute. So you can see it can get very complicated very fast if you're someone who doesn't have a will and you have a really big family and people have died. We have situations, right, where we're looking for 10 different people, right? Because we've got, brothers, sisters, and then their kids, and we're trying to track people down and give them a portion of this estate. And then finally, if you don't have any brothers or sisters or any of their children, then we're going back up to grandparents and kind of their kids and kind of continuing following down through the family tree. So again, it can get quite complicated quite fast if we're kind of left at this last rung. I will say, just kind of another plug for doing this kind of planning, is that you have to remember that at your death, right, people are going to kind of be looking around thinking, okay, who's in charge? What do we need to be in charge of? And they're also going to have a lot of feelings. They might be extremely sad. They might be grieving. They might be angry. They might be, upset with you. They might be upset with other people, right? There are lots of feelings that we have during this time. And then if you have, you have those, those feelings, that grief, and then plus we have other pieces on top of that, right? So we have families maybe who aren't as close as they used to be. Everybody doesn't maybe get along. You have family kind of spread across the country or even across the world. Certain people might feel that they have a right to an inheritance, or they have right to inherit a certain piece of property, a certain thing. You've got, various, marriages, kids from different parents. You kind of see where I'm going, right? So we've got a lot of things going on. And now if we don't have a will, we don't have a document that's even guiding us in what to do. And we don't know that person's wishes, it can feel even more complicated and more overwhelming. And the other piece is, a lot of times when people are coming in after someone has died, right, the person who has died really was, they were the glue that held everyone together, right? They were the ones who were sending out invites for family gatherings, and they were the ones sending out cards and kind of smoothing things over, with the one sibling who wasn't always engaging with the rest of the family. And now that person's gone. So for all of these reasons, kind of having a plan in place, trying to make it easy for those that you leave behind, it really is a gift that you can do today, that you can give them now, and trying to plan for some of these things. I would say overall here in the US, we're not as great at talking about death and dying and what happens after we die. But it really is important. All right, my favorite question is, do I need a lawyer? And I get it. We're not always cheap, right? And this, again, not fun to talk about, not always fun to spend money on. So I understand the rationale for wanting to kind of do it yourself. So I found this, which I thought was kind of funny. Was they were sad when they found out that their wealthy grandfather had died in an earthquake. They were devastated when they discovered he had written his will on an Etch-a-Sketch. So clearly, no one would actually do that, hopefully. But if you had a lawyer, they would, advise you against against doing that and the risks of having your will on an Etch-a-Sketch. One role of the attorney is, yes, we are filling out documents, right? And yes, we are putting in names and addresses and phone numbers, but hopefully we're also counseling you on the process of what happens when you die, and also helping you get organized. So most firms are going to have a questionnaire, and it's going to ask you some really detailed questions. And it might feel a little invasive at times, but really what we're trying to do is to figure out, what do you have and how do you have it? Whose name is on it? Are you a joint owner? And really with that, I find a lot of clients come in and they'll say, oh my gosh, I totally forgot about this retirement account that I had from a job 20 years ago, right? Because it doesn't have much money in it and it's something that I'm not using right now, but I totally forgot about it and I had the wrong beneficiaries named, right? So it's a whole process, right? We need to go through and figure out where things are and then how they're titled and owned. And then also if there are any beneficiaries on them, or POD or TOD. So we kind of go through this whole list, right? So real estate, usually we know what we've got an interest in, but sometimes it can be a little bit different, right? Oh, I'm a 10% owner of a cabin in northern Wisconsin, or I have a timeshare in Nevada, right? It's thinking through all of those interests that you might have. I have down here entrance fee, which is another way of saying, so a lot of my clients who are older, they've now bought into either, a life lease, an assisted living facility, right? They've paid some money down and then using that as part of their stay there. That's money we want to think about. Think about what's happening after your death. Bank accounts, retirement accounts, any other stocks, LLCs. Did you create an LLC for your family cabin? Do you have kind of your retirement hobby business and you've got an LLC? Do you have a bank account with that, right? Thinking through all of our assets, how they're titled, and if we have any beneficiaries. Uh, Vehicles, big one. You know, the asset limit for a probate today is $50,000. Well, a lot of vehicles now have actually kind of surpassed that. I can't say I've ever opened a probate just for a car, but there might be some where we'd have to be either thoughtful about it or think about how many vehicles you had. And if you had a lot of vehicles, right, potentially maybe needing a probate or another process to transfer those out. And then also timeshares. And then kind of some of the newer assets, I'm still not seeing a ton of these, but they are certainly out there. So kind of our crypto, right? Our NFTs, non-fungible tokens, whoever owns them. In some places, you can name a beneficiary on those accounts. In other cases, it's just here's my key and someone will need to find it, and it is a little bit complicated. And then I just also have a plug for setting up legacy contacts. So places like Facebook or Meta, Apple, Google, you can actually set a legacy contact for someone else to either close down your account or to have access to it, depending upon that company. And then finally, password managers. You're not really supposed to log in as somebody else. However, even just having a password manager and having someone know where you have a password for what company might help clue them into different accounts that you have, right? So trying to stay again a little bit organized, especially as life gets more complex and we just have more things in the digital world. So I've given you a few resources here of other places to go outside of attorneys. The state bar has some good resources. There are different county programs. Dane County has an estate planning clinic if you qualify based on your income, I believe. There are some law school clinics. Here we don't have any for estate planning per se. Other places might. There are some free online programs. So whenever there's August is Make a Will Month, so you might get messages from different nonprofits of, hey, you can use this, make your will, and then if you want to include us as part of your plan, right? This is how you would name our organization. I don't think any of those programs are bad per se. I think they, help kind of engage you in the process and get you going. I would say really pay close attention to how those documents are executed. So in Wisconsin, a will needs to be witnessed by two disinterested witnesses, two disinterested people. And then the next component is what we call a self-proving affidavit, where the witnesses sign, the person doing the will signs, and then you have a notary sign. I've seen that execution botched a few times. I had someone who was inheriting in the will serve as a witness. Can't do that. The dates didn't all match up, right? So lots of ways in which just you need to be really careful about how you're putting all of that together. And then for advanced directives, the Department of Health Services, they also have these forms online with the Wisconsin Medical Society. They use honoring choices. So you can find some of these documents out there. Again, you just want to really pay attention to, filling them out, properly dating them in all of the right spots, and then making sure that if the document requires a witness, that it's somebody that's, what we call disinterested. So not inheriting and not related. All right, so other things that I kind of go through with my clients are where are you going to store original documents? So in this world, having an original document is still pretty important, especially if that will might be contested, right? If someone is going to challenge that will for whatever reason. So you want to keep them in a safe place. Some people have safe deposit boxes. I'll just say with that is they're perfectly fine to use. You just want to make sure that someone else will have access to it after your death. Otherwise, there can be challenges in getting into the box, having to drill it, those kinds of things. Having a safe place at home, whether it's just, you know, a fireproof box that is somewhat secure. That's what I do, but making sure that they're in a good place. Thinking about who needs access to the documents and when do they need access to them. So again, with that safe at home, I want to make sure that someone, our executor, they're able to get into that if they need to. They know where the key is or the code is. I tell clients, you have done this, right? And it's really a snapshot in time. I'm hoping that we have thought through a lot of things, right? I'm hoping we thought through, okay, if my primary person dies, do I have a secondary person? Or if, you know, my husband dies, right? Where does everything go after that? But that changes. So I tell people, even once you have this planning in place, it's a good idea to think about it just every, couple of years, 3 to 5 years. Doesn't mean you have to go back to an attorney and then you have to revise anything. It's just something that you want to think about every couple of years. And then also think about after any kind of major event, right? So if there's a death, divorce, disability, somebody moves to a different country, right? Other reasons why you might want to name somebody else as a different healthcare power of attorney, or you might want to change the distributions in your will. As much as you can, just thinking about family dynamics after you're gone. Of course, none of us can really predict that, but just thinking about and picking people in your plan that you think are going to be fair and do a good job and are going to be able to handle any responsibility that comes their way. There are a few things, books, I think there also can be helpful. So just one version, there are a number of these out there, kind of the I'm dead now what organizers. They're a good place for you to store all the information we've talked about, but also things like, you know, if I have a pet, right, this is their veterinarian. This is who you should contact. This is who I'd want to invite to a funeral. This is what I do or don't want at a celebration of life. This is my insurance, my subscriptions you need to cancel, right? So it kind of goes through all those kinds of things. And then the other three are really just various books to get you think about. The last two primarily about healthcare, but just thinking about, all right, how are we trying to make this again easier for the next generation, whoever is left behind, in making sure that, while they're going through the grieving process, they're able to really manage my property, manage my estate in a way that is easier, not too painful, and that they can really move forward with. I will say the beginner's guide to the end. It is not Wisconsin specific, but it's just general topics about how to kind of prepare for the end. All right. And I saw a number of things coming in through the chat. If there are questions, it looks like we do have a couple of minutes where we can talk about.
We had some really good questions come in. First and foremost, thank you so much, Amy, for that wealth of information. We'll do our best to try and get to as many of these as possible. First one, saw this one pop up a lot. Either folks tuned in a little late, maybe wanted to rewatch a part. This event is being recorded, and the recording will be shared to the email address in which you used to register. We try to get those recordings out within a couple days, so keep an eye out for that. Let me go ahead and poke through some of these questions, trying to get to them in the order in which they came in. You did address a handful of these, so I'm trying to kind of parse through some of these here, Amy. This one was interesting. How about if you have a partner, you never married, but you lived together for over 20 years in regards to kind of handling one's estate? Any
Mm-hmm.
high level kind of information, anything changes based on kind of what you had shared
Yeah.
in those broader frameworks?
Yeah, so common marriage does exist in some states. Best of my knowledge, it really doesn't exist here. Um, there are a few kind of small exceptions about where someone potentially, like if you shared a house, for example, you both put money into the house. But no, there isn't anything in the statutes that allows for any kind of long-term partner, common law marriage. And so that is the place where you'd want to make sure that you've got things in writing. It doesn't mean that you need to change ownership of anything now, but just making sure that your partner is included in your planning. And I would say that goes for powers of attorney and then also for a will or a trust or whatever kind of estate planning document you use.
Awesome. This question came up too and was kind of thought-provoking for me, just based with all of the, tools and resources that are available to folks, and kind of the ease to access a lot of the information. Obviously, online options don't really replace working with an attorney, but what are your thoughts on working with an attorney versus the online options that are available? Maybe when might it make sense to use the online options versus maybe when it's time to then get in contact with an attorney?
Yeah, I think that the general document, so yes, there are a number of different software tools out there. So the general documents, as long as they're tailored to Wisconsin, and I'm finding that for the most part they are. But I had an example one where someone came in with a completed will and everything was left to the spouse first. Well, that person wasn't married, but somehow in the software they might have checked no, they didn't have a spouse, but that didn't get deleted. And so hopefully it would have been no harm, no foul. But ultimately, clearly there were some pieces that just kind of got missed in that software. So I would just say if you're using software, one is just make sure that you thoroughly review it before you sign it and just don't expect that it'll have everything, everything correctly as you filled it out through, the software tool. Make sure that you've got your witnesses. And then I would just say that, one common example is, let's say things are pretty straightforward. Maybe you're not married, but you have two adult children. They get along really well. Maybe that tool can be really good for you to fill out certain documents. But if you're trying to avoid probate, and you've got a house, right? But you haven't done a transfer and death deed for that house, the house is going to go through probate. Again, it's still going to get to your kids. So maybe kind of no harm, no foul, but maybe in that scenario, doing a transfer and death deed would actually make sense. You could avoid probate. It might be easier for your kids. So there might be some level of, kind of information or expertise an attorney can help in avoiding the probate process at that point.
Awesome. Thank you so much for that. We got a bunch more questions that came through. A lot of really
Sure.
curious folks, right? So
Oh,
I thought this
good.
one was really might be pertinent to a lot of the folks who are tuning in today. So this individual stated that they had a Rev Trust done 10 years ago because they
Mhm.
were a blended family. Now the kids are all over 18 and need to redo the trust. Is it easier to start over fresh since they aren't minors and many things have changed, or is it easier to go back to the original attorney just to amend it?
Yes. Okay. So I do come across this scenario a lot, and I will say that by and large, if it has been a significant amount of time since you had that first trust done, what we are probably doing is what is called a restatement of your trust, which is a fancy way of saying we're keeping the title of your trust. So you don't have to go back and retitle everything or change the name of your trust. But otherwise, we're really taking out the entire guts of your trust and we are replacing it with all of the new stuff, right? So new laws, probably new trustees, new provisions, right? Maybe you don't need trust for all the kids anymore. Maybe you do. So at that point, I don't know that it really matters if you go back to the same attorney or not, because you're not starting over, but you kind of are, right? Because there are just so many different changes and laws have changed. And my guess is that attorney probably would be doing the same thing I would be, is probably just kind of starting over.
Gotcha. Thank you for that. Pretty straightforward question, probably maybe a more of a nuanced response, but do you inherit the debt of the deceased person if there are no assets?
Ooh, that is a really new nuanced question. We do have probates that are underwater. Part of it, I would say, generally speaking, the answer is no, not really. If we are in a probate process, right, where we're within the court process, we usually have a hearing at that point to maybe there are 10 creditors, right? And maybe the estate has $10,000. We're figuring out of those 10 creditors who gets what, right? So no one's going to get their full share, and there might not actually be money left for anybody to inherit. Um, Now, if you're married, that's probably also kind of another question, right? Do you inherit the debt of your spouse? What are you still responsible for? Um, I think that's probably all I can say about that because it is pretty nuanced. But technically speaking, no, you're not really inheriting the debt of others.
Sure. Okay. Thank you. Thank you
It's
for that.
really it's payable by your estate. So depending on what's in your estate, and it gets even more tricky if you've got beneficiaries named on different policies, right? That wouldn't technically be part of your estate. So yeah.
Had an interesting question come through. What do you do if you don't want to inherit your parents' timeshare? And maybe we can use that as a blanket question. Like, what happens if you're set to inherit something based from a deceased person, but maybe you aren't interested in obtaining it? What are the
Yes.
options for folks?
So I will say, just generally speaking, timeshares are kind of a minefield. Everyone's done a little bit differently. And so some have actual deeds, and it might be possible to work with an attorney in that state because it's usually not in Wisconsin to get some kind of process going, or if your parents can relinquish it during their lifetimes, also can be helpful. There aren't a lot of attorneys out there that even do that kind of work unless it's kind of a predatory practice. So that's kind of my timeshare answer. But generally speaking, if I'm going to inherit something, if I disclaim it, I decide to disclaim it, it just kind of keeps going down on through the heirs at law. So let's say I decided I didn't want anything from my mom and I wanted it instead to go to my nephew. If I disclaimed it, it actually would just keep going down the line, the laws of intestacy of my family members. And so a better practice might actually be for me to accept it and then actually gift it to my nephew if I wanted to give it to a very specific person, if that makes any sense. So we have situations where somebody wants to disclaim, but they want it to go to a specific person that isn't kind of next in line, right? So then the disclaimer becomes more of an issue.
Gotcha. Okay. Last question. It's unfortunately we ran out of time again. Thanks so much for all these wonderful questions. Thank you, Amy, again for putting this together and taking time out of your day to share this insights and wisdoms here with us all. Okay, this question pertains to an IRA. So if an IRA does not have a designated beneficiary and therefore was cashed out and deposited into an estate account, does the estate pay taxes on the IRA, or do the beneficiaries of the estate pay taxes on that portion? Uh,
Good question.
yeah,
It's probably better answered by a tax attorney or a
sure.
CPA. I will just say, in my experience, is usually whoever's preparing any kind of return or accounting as part of the estate, they're preparing what's called a K-1, and oftentimes, yes, the beneficiary would be paying the tax. Oftentimes, the idea behind that is that the beneficiary is at a lower tax bracket than an estate or a trust would be.
Gotcha.
So while
Wonderful.
it can be painful for the beneficiary, again, the idea is that there's some kind of tax savings.
Certainly. Certainly. Well, that's all the time, unfortunately, we have for audience questions again. Thank you, Amy, for putting together this wonderful presentation. If you folks had any questions or follow-up or wanted to get in contact with Amy, I know her contact information is on the screen right there. Amy, here at DreamBank, we are a community that is built up of fellow fearless dreamers. We always like to ask our presenters, what's one piece of advice you have for someone who is actively pursuing a dream right now?
Oh my goodness. I didn't know you were going to ask me this. I would say, so I'm listening to the book Atomic Habits right now.
Sure.
And I'm enjoying it because it's really helping me to kind of break down some of those goals and
Hmm.
trying to figure out how to accomplish something, a dream, right? And measuring that, putting it into measurable bite-sized bits, right? And so if I want to eat healthier, that's really not my dream. My dream is, right, I'm going to buy this food, I'm going to make this snack, I'm going to take time on Saturday to do XYZ. So I think breaking things down into small bite-sized pieces and then really just celebrating every win that you have and being kind to yourself. It's more than one thing, but that's what I'm doing right now.
I love it. Some great a great way to end there. Amy, thanks again. Thank you all for taking time out of your day here. To all of you who joined the session, thanks so much. You can learn more about DreamBank's free upcoming programming at amfam.com/DreamBank and by connecting with us on all of our social channels. On behalf of American Family Insurance DreamBank, we look forward to hosting you again. And until then, keep dreaming fearlessly. Take care.
All right, thank you.